Hello to all those who are following my videos and to those who are new to my channel. I am Silver De La Rosa and I welcome you to On Silver Screen, where learning is interesting. Today we are going to embark on a new season that is contract practice, and in this episode we'll talk about contract law. I would like to ask for your support by hitting like on the video and sharing the video to your friends, especially those who are preparing for their APC. And if you haven't done yet, please subscribe to my channel and turn on the notification bell so that you will be notified every time I upload a new video. To begin with, our objective for this discussion will be we are going to discuss contract practice as a QS competency, and we are going to proceed with discussion of contract law. Here we are going to talk about the formation of contract, the key elements of a contract, the legality of the contract, contents of a construction contract, terms and conditions of a contract, and execution of contract. Now, let us start. Contract practice. For quantity surveyors, contract practice is a core or technical competency which requires the understanding of the following aspects of the contract: the basic contract law and legislation, such as what are the requirements for the formulation of contract, what are needed in order for a contract to be legal and enforceable, and what are the third-party rights, including relevant legislations and the use of collateral warranties. These are only few of the basic knowledge that a quantity surveyor must have with regards to contract law. Then, a quantity surveyor must also know what are the standard forms of the contract used in construction industry, and when these different forms of contract will be used. Also, a quantity surveyor must understand contract documentation, how to prepare a contract document, and what should be included in these documents. Also, a quantity surveyor must understand the contractual mechanisms and the applications and procedures of these contractual mechanisms at the various stages of the contract. I could say that contract practice is about knowing and selecting the right ingredients in order for you to formulate your contract. Now, let us define what is a contract. A contract is a legally binding agreement between two parties. Since it is legally binding, it can be enforced by law, or it is enforceable by law. And it is an agreement, therefore it should be mutually agreed by both parties. So, how a construction contract is being formulated, or what is the formation of construction contract? So when parties intended to create a legal relationship in consideration of their mutual commercial interest, let's say, for example, the contractor and the client, and the contractor offers to design, build, or supply materials and labor for the project of the client, and this offer is accepted by the client, and the client considers or promises to pay the contractor with a certain amount with regards to the services to be rendered by the contractor, then the agreement was formed. So the agreement is reached when one party makes an offer which is accepted by the other party. So that is how a contract is formed. Now, there are key elements of the contract, and these are offer, so there must be an offer, and the offer must be accepted, or the acceptance of the offer, and there should be a consideration. So while undertaking all these elements, there must be an intention to create a legal relationship. So these are the key elements of the contract. Let us discuss deeper into these elements of the contract. First, let us talk about the offer. An offer is a promise or expression of willingness by the offeror to be bound on a certain specified terms upon the unqualified acceptance of these terms by the person whom the offer was made, or the offeree. So provided that the formation elements, the one that we have discussed earlier, for example, the consideration and the intention to create legal relations are present, the acceptance of an offer will result in a valid contract. Now, the offer must be made with objectively ascertained intention to be bound in order for it to be valid. It is worth noting that invitation to treat does not necessarily constitute the offer. When the offeror no longer wants to proceed with the offer, he can terminate the offer. So the offer may be terminated by various ways of withdrawal prior to acceptance, provided there is a communication of the withdrawal to the offeree. Also, in the absence of an express stipulation as to time, an offer will lapse after a reasonable time. So if you notice during the tender, the tenderer always put the tender validity period. And if tender validity period expires before you award the tender, then the offer may be considered as terminated. That is why, if you are the one handling the tender and you need more time, you have to request the tenderer to extend the validity of its tender offer. So these are only few of the reasons or few of the ways that the offer can be terminated. Now, offer can also be rejected in various ways. One of them is the direct rejection or the non-acceptance of the offer, or making a counteroffer. Making a counteroffer kills the original offer, or making a variation to the original terms. So these actions may considered as rejection of the offer. Let us now talk about acceptance. Acceptance is an unconditional and unqualified assent to the terms of the offer by the offeree. This assent may be expressed through words or conduct, but cannot be inferred by mere silence save in very exceptional circumstances. And construction contracts does not fall on these very exceptional circumstances. Acceptance must generally be communicated to the offeror, and in construction contracts, acceptance must preferably be in writing. So when we accept the offer, normally what we give is that we issue a letter of intent or a letter of award. We will talk about the difference between the letter of intent and letter of award in the next videos. For acceptance of an offer to lead to a binding contract, the acceptance must state which offer was accepted. How about counteroffer? Counteroffer must not be construed as acceptance as it rejects the original offer. As mentioned on the previous slide, that a counteroffer kills the original offer. Let's see how counteroffer works. Let's take a look at this contractor and client. The contractor offered to build the project for a price, let's say, of 100 million. The client say that it will award the contract to the contractor for a price of 80 million. So now there is a change in terms. From 100 million, the client counteroffered 80 million. This now puts the contractor in a position of accepting the offer because it is now the client who is giving a counteroffer. So the contractor may reject or may accept. And in this instance, the contractor rejects the counteroffer. So sorry, I cannot accept it. And supposing the client agreed to 100 million, can we consider this as acceptance of the offer? No, we cannot, because now it is still a counteroffer by the client. It should be accepted by the contractor. So the contractor at this point may also accept or reject the offer. And let's say at this instance, the contractor still reject the offer. So since there is no acceptance of the offer, there is no contract. So as long as the offer is not accepted, it does not become legally binding. But once it is accepted, it becomes legally binding, it becomes a contract, and it becomes irrevocable. How about consideration? What is a consideration? A consideration is something of value, as defined by law, requested for by the party making the promise or the promisor, and provided by the party who receives it, which is the promisee, in exchange for the promise that the promisee is seeking to enforce. So consideration actually is a legal word for money that is paid for the supply of goods or services, or simply what we call the terms of payment. In the absence of the element of consideration, makes the contract non-binding. So this is very important, that a consideration must be there in order for the contract to be binding. We had mentioned earlier that a contract is legally binding and it is enforceable by law. So what makes a contract legal? In order for a contract to be legal, it must fulfill the following requirements. First, there must be an intention to create legal relations between the parties. In the absence of contractual intention, an agreement, even if supported by consideration, cannot be enforced. Whether the parties to an agreement intended to create a legally binding relations between them is a question determined by an objective assessment of the relevant facts. Next is that there must be a genuine consent. The contract must not be procured by mistake, force, under duress, undue influence, unconscionable conduct, or misinterpretation. Once these elements are present in the procurement of contract, it can make the contract void. Then there must be a legality of the object. So what does it mean? The parties must not agree to something illegal or against the law. Of course, when you contract something that is illegal, by default, it's not valid, it's not enforceable by law because it is illegal in the first place. And then there must be a legal capacity to contract. What does it mean? We have to think about legal capacity first. This is subject to applicable law. Who has the legal capacity to contract? Next is that the authority to contract. Who has the authority? Authority means that a person who is permitted by the company to sign and enter into a contract. It is because that an individual may have a legal capacity but is not authorized by the organization. So for example, a secretary of the company is in legal capacity to carry out contracts, but he is not, or he or she is not authorized to sign the contract documents. Therefore, if this person will be the one to sign the contract documents, the contract is also void because the person who signs it is not authorized by the company. So that is the legality or the legal capacity to contract. We must check and make sure that the one who signs and countersigns the contract documents are authorized by the company. Now, let's talk about the contents of a construction contract. What can we normally see in a construction contract? The construction contract may contain the following: contract agreement, or this is where both parties signs. Letter of award or letter of acceptance. Some call it as letter of acceptance also. Form of tender, specifications, drawings, conditions of contract. So there can be a general condition and a particular condition of contract. Also schedules, schedule of works, bill of quantities, schedule of rates, schedule of day work rates, and so on. And there are the other documents. What are these? For example, you have the correspondences that will form part of the contract, some templates or pro forma. Let's say you have the template for novation agreement. And you also have some appendices or anything that you want to include in a contract. So we often talk about terms and conditions of the contract. But do we really understand what is a terms and conditions of the contract? Let us discuss this here. Terms of the contract. This refers to the provisions in the contract or the provisions of the contract. There are express terms and implied terms. So what are these? Express terms in a construction contract is a term that is expressly written down in the contract document and agreed between contracting parties. So it is express terms are expressly provided. You can read it in the contract document. While the implied terms, these are the terms that are not expressly included in by the parties in the contract, but are implied by law. So even though it is not recorded in the contract, but it is implied by law or it is required by law, then it can be considered as implied terms of the contract. So implied terms must not contradict the express terms. That's one thing. Next is that implied term implied in fact only if necessary. What does it mean? Implied terms fill the gap in a contract so as to give effect to the presumed intention of the parties. The term is implied in fact and depends on the consideration of the language of the contract as well as the surrounding circumstances. So that is how the implied terms works. Now, there are also classifications with regards to the terms of contract. What are these? These terms of contract can be classified as a condition, a warranty, or innominate terms. Let us discuss each one by one. A condition is a fundamental term that, if breached, gives the agreed party the right to either terminate the contract or affirm it. In addition, the aggrieved party can also claim for damages. So this is the conditions of the contract. While a warranty is a term that, if breached, does not give the aggrieved party the right to terminate the contract, but it gives the right to claim for damages. So it is warranty. While innominate is a term that does not fall within the first two classification, where the remedy for breach will depend on the effect of that breach at the time it happens. If there is a substantial effect on the agreed party, it will be likely a fundamental term and give the right to that party to terminate the contract and claim for damages. But if not, if it is not that substantial, the effect is not substantial, then the party may only claim for damages. So that is what we call innominate terms of the contract. What is contract execution, or how do we execute a contract? Contract execution is the process of signing an agreed contract, after which its terms become binding on the parties to the contract. So signing of the contract or executing the contract may be done by under seal or underhand. So what are these two? Contract under seal or executed as deed, it is signed by the directors or company secretary. So there's a lot of formality on this type of contract signing. It can be signed by either two directors of the company plus the secretary, or one director and one secretary, depending on the setup. Then it may require a company seal. Currently, contract under seal may not require company seal. It can be executed using signature alone. But some companies still apply the company seal. And it must expressly be stated that the contract is being executed as a deed. While underhand or execution of contract underhand is also what we call a simple contract. It is signed by the company's authorized representative. So whoever from the company, as long as this person is authorized by the company, can sign the contract. It doesn't need to be the company director or the company's secretary, as long as the person is authorized by the company. Contracts executed under seal has a longer limitation period compared to contracts executed underhand. So this is the major difference between the two, the limitation period. So what is a limitation period? Limitation period is a maximum period of time set by statute within which a party to the contracts can bring about a claim. So what type of claim? For example, claims with regards to latent defects, damages, and so on, any type of claim. This concludes our discussion for the basics of construction contract law. Join me next on Silver Screen as we discuss types of contract for our episode 2. If you enjoyed the video, please hit like on the video, and please don't forget to share the video to your friends, especially those who are preparing for their APC. And if you haven't done yet, please subscribe to my YouTube channel and turn on the notification bell so that you will be notified every time I upload a new video. Thank you for watching, and see you next episode.